நம்மிடம் அறிமுகப்படுத்துவதற்காக பேராசிரியர் சரஸ்வதி அவர்களை அழைக்கின்றேன். We start the Kannabiran Memorial Lecture to be delivered by Justice Wigneswaran, and Professor Saraswati will briefly introduce Justice Wigneswaran to us.
K.G.Kannabiran நினைவு சொற்பொழிவு நிகழ்ச்சியில் பங்கேற்க வந்திருக்கின்ற மேடை மீதும் மேடைக்கு எதிரேயும் வீற்றிருக்கின்ற ஆளுமைகளே, பெரியோர்களே, நண்பர்களே, தோழர்களே, உங்கள் அனைவருக்கும் என் பணிவான வணக்கத்தை தெரிவித்துக் கொள்கிறேன். இந்த கூட்டத்தின் சிறப்பு சொற்பொழிவாளர் ஈழத்தின் வடக்கு மாகாண முதல்வர் மாண்புமிகு நீதிபதி திரு விக்னேஸ்வரன் அவர்களை அறிமுகப்படுத்துகின்ற பணி எனக்கு பணிக்கப்பட்டிருக்கிறது. சூரியனை அகல் விளக்கு கொண்டு விளங்கப்படுத்துகின்ற ஒரு முயற்சி தான் என்றாலும் கூட அது எனக்கு பெருமை சேர்க்கும் முயற்சி என்ற காரணத்தினால் மகிழ்ச்சியோடு ஏற்றுக்கொண்டிருக்கிறேன். இந்த நல்ல வாய்ப்பை எனக்கு நல்கிய PUCL பொறுப்பாளர்களுக்கு என் நன்றியை தெரிவித்துக் கொள்ளுகிறேன். இலங்கை அரசு அதிகாரியாக பணியாற்றிய திரு கனக சபாபதி ஆதிநாயக இணையருக்கு மகனாக பிறந்த விக்னேஸ்வரன் அவர்கள் அவரது விருப்பத்தின்படி பயில அனுமதிக்கப்பட்டிருந்தால் இன்று பண்டிட் ரவிசங்கர் போல ஒரு புகழ்மிக்க சித்தார் வித்வானாக பரிணமித்திருப்பார். இவர் வழக்குரைஞராக ஆக வேண்டும் என்பது அவருடைய தாயாரின் பெரு விருப்பம். அதன் காரணமாகவே தான் அந்த படிப்பில் சேர்ந்ததாக குறிப்பிடுகின்ற திரு விக்னேஸ்வரன் அவர்கள் படிக்கின்ற காலத்திலேயே தன்னுடைய மாணவ பருவத்திலேயே ஒரு மாணவ தலைவராக படை பயிற்சியாளர், கேடட் என்று சொல்லுவோமே, குத்துச்சண்டை மற்றும் ஓட்டப்பந்தய வீரராக, தமிழ் மற்றும் ஆங்கில பட்டிமன்றங்களின் அணி தலைவராக, பள்ளி ஆண்டு மலரின் ஆசிரியர் என்ற தன்னுடைய பன்முக தன்மையை வெளிப்படுத்தியிருக்கிறார். தன்னுடைய இளம் கலைஞர் பட்டத்தை லண்டன் கேம்பிரிட்ஜ் பல்கலைக்கழகத்திலிருந்தும் LLB பட்டத்தை இலங்கை பல்கலைக்கழகத்திலிருந்தும் பெற்றவர். சட்டக்கல்லூரியில் 1962 மாணவர் தலைவராக செயல்பட்டிருக்கிறார். பின்னாலே அவர் குறிப்பிடுகிறார், 1962 நான் சட்டக்கல்லூரியினுடைய மாணவர் தலைவர் பொறுப்பை ஏற்றதற்கு பின்னாலே ஒரு தமிழ் மாணவன் கூட அங்கே அந்த பொறுப்பை ஏற்க முடியவில்லை என்று அங்கே நிலவிய சூழலை அந்த ஒற்றை வரியில் நமக்கு தெரிவிக்கிறார். சில காலம் வழக்கறிஞராக பணியாற்றிய திரு விக்னேஸ்வரன் 1972 நீதித்துறையில் இணைந்தார். கீழமை நீதிமன்ற நடுவராக மாவட்ட நீதிபதியாக பணியாற்றி பின் 1988 உயர்நீதிமன்ற நீதிபதியாகவும் 2001 உச்ச நீதிமன்ற நீதிபதியாகவும் பொறுப்பேற்றார். 2004 35 ஆண்டுகால நீதிபதி அனுபவத்தை பெற்றவராக பணி ஓய்வு பெற்றார். 2013 இலங்கையில் நடந்த வடக்கு மாகாண தேர்தலில் தமிழ் தேசிய கூட்டணியின் முதலமைச்சர் வேட்பாளராக களம் இறங்கி வெற்றி பெற்று 7/10/2013 வடக்கு மாகாண முதல்வராக பொறுப்பேற்றுக் கொண்டார். முதலமைச்சராக பொறுப்பேற்றுக் கொண்ட பின் திரு விக்னேஸ்வரன் அவர்கள் மேற்கொண்டிருக்கும் முதல் வெளிநாட்டு பயணம் இது. அரசு சாராமல் தனிப்பட்ட முறையில் நம் அழைப்பை ஏற்று தமிழ்நாட்டிற்கு வந்திருப்பது நமக்கெல்லாம் பெருமை சேர்க்கும் ஒரு செயல் என்றே நாங்கள் கருதுகிறோம். மரியாதைக்குரிய நீதிபதி அவர்கள் சேஃப்கார்டிங் செக்யூரிட்டி அண்ட் டெமோக்ரஸி என்ற தலைப்பிலே இங்கே உரையாற்ற இருக்கிறார். ஐயா, முள்ளிவாய்க்கால் போர் முடிந்த பின்னாலே நாங்களும் கூட எதிர்பார்த்தோம் ஈழத்தமிழர்களுக்கு ஒரு அமைதியான வாழ்க்கை திரும்புகிறது என்று. ஏனென்றால் அப்படிப்பட்ட ஒரு வாக்குறுதியைத்தான் ராஜபக்ஷ அவர்கள் கூறினார்கள். I have wiped out terrorism and delivered peace to the people என்று. ஆனால் அதற்கு பின்னாலே கடந்த 5 ஆண்டு காலமாக எங்களுக்கு கிடைக்கின்ற செய்திகள் எந்தவிதமாக எங்களுடைய துன்பத்தை, ஆதங்கத்தை, ஏக்கத்தை அதிகப்படுத்துகின்ற செய்திகளாகத்தான் இருக்கின்றனவே தவிர போர் முடிந்த பின்னாலே அங்கே எல்லாம் சரியாகிவிட்டது அல்லது சரியாக்குவதற்கான முயற்சிகள் நடந்து கொண்டிருக்கின்றன என்ற ஒரு செய்தியை கூட எங்களுக்கு தரவில்லை. அதற்கான காரணத்தை நீங்களே சுட்டி காட்டியிருக்கிறீர்கள் மிக தெளிவான வார்த்தைகளால். பெரும்பாலானவர்களின் நம்பிக்கைக்கு மாறாக போரின் முடிவு உண்மையிலேயே இனச்சிக்கலை ஆழப்படுத்திவிட்டது. ஏனெனில் இனச்சிக்கலுக்கு அடிப்படையாக உள்ள காரணங்கள் சரிவர அணுகப்படவில்லை என்பதோடு சில வழிகளில் அக்காரணங்கள் மேலும் அதிகரித்துவிட்டன. இந்த நாட்டில் பெரும்பான்மை இல்லை என்றும், எனவே நாம் அனைவரும் ஒரே மக்கள் என்றும் பிரகடனப்படுத்துவதில் எந்த ஒரு பொருளும் இல்லை என்று சொல்லியிருக்கிறீர்கள். Contrary to popular belief, the end of the war has actually deepened the ethnic conflict. This is because the underlying cause for the conflicts have not been addressed and in certain ways exacerbated. There is no point in declaring that there is no minorities in the country and that we people are one என்று மிக தெளிவாக நடந்து முடிந்த போர் தமிழர்களுக்கு எந்த விதமான நிம்மதியையும் தருவதாக இல்லை. ஏனென்றால் அதற்குரிய காரணங்கள் இன்னும் அகற்றப்படவில்லை என்று கூறியிருக்கிறீர்கள். அருமை ஐயா அவர்கள், உங்கள் நாட்டிலே இந்த சிறுபான்மையினர் பெரும்பான்மையர் என்ற அந்த கணக்கு எப்படி போடப்படுகிறது என்பதையும் மிக அழகாக விளக்கியிருக்கிறீர்கள். இந்த பெரும்பான்மை சிறுபான்மை கணக்கெடுப்பு எத்தகைய சூழ்ச்சியோடு உருவாக்கப்பட்டது என்பதை நீங்கள் உச்சநீதிமன்ற நீதிபதியாக பதவியேற்கும் விழா ஏற்புரையில், அதாவது உச்சநீதிமன்ற நீதிபதியாக, அப்பொழுது அவர் அரசியலுக்கு வரவில்லை, முதலமைச்சராக இருந்ததை முடிச்சிடறேன். 2 மாகாணங்களின் பெரும்பான்மையினர் 7 மாகாணங்களின் பெரும்பான்மையினரோடு சேர்க்கப்பட்டு பின் அதன்படி 9 மாகாணங்களின் சிறுபான்மையராக ஆக்கப்பட்டவர்கள். இது ஒரு புதுமையான கணக்கிடல் முறை என்று குறிப்பிட்டிருக்கிறீர்கள். வடக்கு மற்றும் கிழக்கு மாகாணத்தில் மிக பெரும்பான்மையோரின் குறிக்கோள் தங்கள் உரிமைகள் தங்களிடம் ஒப்படைக்கப்பட வேண்டும் என்பதுதான், அதிகார பகிர்வு அல்ல. The vast majority of the denizens of the north and the east seek the restoration of their rights, not devolution of powers. These are rights which were snatched away from them by virtue of a mathematical innovation where the majority in the 2 provinces were added to the majority in the 7 provinces and thus made a minority in the provinces. மரியாதைக்குரிய ஐயா, ஈழத்தமிழர்களை பற்றி தொப்புள் கொடி உறவு பூண்ட எங்களுக்கெல்லாம் மிகுந்த கவலையும் அக்கறையும் இருக்கிறது. அங்கே நிலவுகின்ற பிரச்சனை ஏதோ அந்த மண்ணுக்கு மட்டுமே சொந்தமான பிரச்சனையாக இல்லை என்பதை நீங்கள் அறிவீர்கள். எனவே இது குறித்து உங்களுடைய மேலான கருத்துக்களை, மேலான பார்வையை அறிந்து கொள்ளவும், துன்பத்தில் உழலுகின்ற ஈழத்தமிழருக்கு சரியான விடியல் எப்பொழுது எந்த வழியில் கிடைக்கும் என்பதை உங்கள் வாய்மொழியாக தெரிந்து கொள்ளவும் நாங்கள் ஆவலோடு காத்திருக்கிறோம். இப்பொழுது நீதிபதி முதலமைச்சர் திரு விக்னேஸ்வரன் அவர்கள் தன்னுடைய உரையை ஆற்ற இருக்கிறார்கள். அவர் முதலில் ஆங்கிலத்திலும் அதன் பின்னால் தமிழிலும் உரையாற்ற இருக்கிறார்கள். ஐயா, வாருங்கள், உங்கள் உரையை தாருங்கள்.
மிக்குடைய PUCL வாலண்டியர்ஸ்ட்டை அவர் கொடுத்த புக்லெட்ஸை கொஞ்சம் டிஸ்ட்ரிபியூட் பண்ணிடலாம். ஐயா, நீதிபதி அவர்கள் கூறியிருக்கிறார்கள்.
गुरु ब्रह्मा गुरुर्विष्णु गुरुदेवो महेश्वरः गुरु साक्षात् परब्रह्म तस्मै श्री गुरवे नमः. Honorable Chairman, distinguished guests, members of the family of the late Kannabiran, my dear Bharatian brothers and sisters, we are gathered here today to remember one of India's greatest human rights leaders and jurists, the late Mr. K.G.Kannabiran. He was the president of your People's Union for Civil Liberties, PUCL, from the year 1994 to 2008. His period of office saw PUCL climbing to great heights as a human rights organization. He was, I am told, deeply humble and humane as a person, passionately and intensely committed to protecting democracy and human rights, not just in India, but across the globe. I was also struck by the humility and humaneness of all the members of the PUCL, the manner in which they conduct themselves. Mr. Kannabiran was absolutely fearless in opposing the stifling of freedom and crushing of dissent. He was an uncompromising professional when it came to law and legal practice. He had no doubt inspired many generations of human rights activists and lawyers in India. Moreover, he was a human rights advocate in every sense. He spent the major part of his professional life as a counsel for the defense and was held in high esteem. He appeared for Naxalites, RSS members, and all others who needed his assistance. In Andhra Pradesh alone, he appeared on behalf of some 500 detainees between 1975 and 1977. He gave opposition to the emergency. He was elected as the president of the Andhra Pradesh Civil Liberties Committee and served in that capacity for 15 years. His association with PUCL was legendary. He was able to articulate and advocate many legal principles that sought to give effect to the directive principles of the Indian Constitution. He passed away on the 30th of December 2010. To be invited to speak at his memorial oration from across the Park Strait is indeed an honor, albeit an intimidating one. Not only because of Mr. Kannabiran's stature, or the dedicated and discerning audience gathered here today, but also because having retired from the Supreme Court a decade ago and having borne the mantle of a politician for the last 1 year, perhaps I could face the charge that I have abandoned virtue for vice, reason for passion, and justice for expediency. Quite apart from my inadequacy to contribute meaningfully at the memorial oration of a humane being who has been described as the face of the civil rights movement of the world's largest democracy, I must confess that speaking at an event organized by the PUCL, and particularly one in memory of Mr. Kannabiran, poses certain difficulties. Human rights advocates tend to adopt a moral high ground in their discourses. It is often said that one adopts moral high ground when one has no other ground to rely on. Could that be the case with human rights advocates, particularly those who often decry security and sovereignty? As you know, I am speaking on safeguarding security and sovereignty. I personally cherish these values. All too often, human rights advocates forget that it was that model of American virtue, Abraham Lincoln, who is credited with using the phrase, "The Constitution is not a suicide pact," when he suspended the writ of habeas corpus during the American Civil War. It was articulated formally in the legal context around 90 years later, 90 years after Abraham Lincoln, in Justice Jackson's dissent in a free speech case, Terminilio versus City of Chicago, where he chided the majority of the court thus, and I quote, This court has gone far toward to accepting the doctrine that civil liberty means the removal of all restraints from these crowds, and that all local attempts to maintain order are impairments of the liberty of the citizen. The choice is not between order and liberty. It is between liberty with order and anarchy without either. There is danger that if the court does not temper its doctrinal logic with a little practical wisdom, it will convert the Constitutional Bill of Rights into a suicide pact. There are many followers of this little practical wisdom across the globe. In the aftermath of the attack on Pearl Harbor, the US Supreme Court held as constitutional curfews imposed on persons of Japanese descent in Hirabayashi versus the United States, and supported the internment of more than 100,000 persons of Japanese descent through its well-known decision in Korematsu versus the United States. The respected Justice Hugo Black stated categorically that the case had nothing to do with racial prejudice. So what does it mean? What did he say? Korematsu was not excluded from the military area because of hostility to him or his race. He was excluded because we are at war with the Japanese Empire, because the properly constituted military authorities feared an invasion of our west coast and felt constrained to take proper security measures, because they decided that the military urgency of the situation demanded that all citizens of Japanese ancestry be segregated from the West Coast temporarily, and finally because Congress, reposing its confidence in this time of war in our military leaders, as inevitably it must, determined that they should have the power to do just this, unquote. So that was in the United States. In the UK, in Liversidge versus Anderson, the House of Lords held that they would defer to the decision of the Home Secretary the question of whether he had reasonable cause to believe that the detention of Liversidge was necessary. The celebrated Lord Denning followed the decision in Rex versus Secretary of State ex parte Hossenball in a deportation case, supporting judicial deference in matters of national security. In his work, Landmarks in the Law, he termed Liversidge as a decision made against the background of the danger the UK was in at the time and the necessity to combat the enemies in their midst. In Sri Lanka, too, our courts have amply demonstrated their little practical wisdom. When nearly 350,000 Tamils were incarcerated in open prison camps immediately after the end of the war, a public interest petition was filed claiming that there was no legal basis for such detention and that detention without detention orders was illegal. The Supreme Court and the Attorney General are reported to have queried, with what must have been of great concern to them, whether the petitioners in the case were seeking to imperil the detainees further by insisting that detention orders be issued on them. The Attorney General, on behalf of the state, explained the great threat to security that these people could pose if they were allowed to get back into society, for there were sure to be terrorists in their midst. Surely the lives of 22 million were worth more than the discomfort of a few 100,000. The court reserved order on whether leave should be granted. And you can ask Mr. Sumandran, he will tell you that was 5 years ago. It still needs to be pronounced. In essence, are we not dealing with that famous law school conundrum of a ticking time bomb? Should we torture a terrorist who has information on when a time bomb would explode and kill millions of innocent lives and thus save them, or do we make a suicide pact with the Bill of Rights and die? Can any human rights advocate who claims to have the interests of humans at heart claim that innocence should be sacrificed at the altar of blind subservient to the law? Or what use is liberty without security? Is not security the essence of all rights, the foundation upon which all other rights rest? This brings us to our next question. Who are those who seek to espouse these human rights values? Are not human rights essentially a Western concept? Why should we, who have histories and civilizations that date back to antiquity, subscribe to newfound notions of countries that enslaved and colonized most of the world? Is this not new colonialism supported by NGOs that are simply human rights hitmen? What right do other countries and international organizations have to dictate terms to individual countries? Does it not infringe upon the sovereignty of states? Is not sovereignty the most sacred element of public international law, the foundation even? Are not slogans of R2P, responsibility to protect, simply cloaks for imperialist interventions? Mr. Dilip Singha, the permanent representative of India to the United Nations in Geneva, in explaining India's abstention at the United Nations Human Rights Council vote on the resolution on promoting reconciliation, accountability and human rights in Sri Lanka in 2014 said, and I quote, "It has been India's firm belief that adopting an intrusive approach that undermines national sovereignty and institutions is counterproductive. Any significant departure from the core principle of constructive international dialogue and cooperation has the potential to undermine efforts of Human Rights Council for promoting universal respect for the protection of human rights and fundamental freedoms." The Sri Lankan, that's unquote. The Sri Lankan government's response was more direct. What did they say? The Sri Lanka categorically and unreservedly rejects this draft resolution as it challenges the sovereignty and independence of a member state of the UN, violates principles of international law based on profoundly flawed premises, and is inimical to the interests of the people of Sri Lanka, unquote. The assault of human rights on sovereignty is not something only imagined by countries with a colonial hangover. Britain's former Lord Chief Justice, the patronymic Baron Judge, that's his name, Baron Judge, recently said that the European Court of Human Rights is undemocratic and undermines the sovereignty of Parliament. He went on to say that in any country which embraces the principle of democracy, and certainly in the United Kingdom, ultimate authority over constitutional and societal questions is not vested in a body of judges, however wise and distinguished, and even if the system for their appointment is beyond criticism, unquote. It is not clear whether the learned judge, Baron Judge, was implying that sovereignty is the province of only those countries that embrace the principle of democracy, whatever that phrase might mean, but the idea is clear. The European Court of Human Rights is not welcome as it erodes parliamentary sovereignty. While parliamentary sovereignty is not the same as state sovereignty, the critique is essentially the same. Surely, this is distinguished company following little practical wisdom. Should not human rights advocates reassess their positions? Should not they endeavor to gain some practical wisdom? Alas, I seem to lack this little practical wisdom. More than a decade ago, as a judge of the Supreme Court of Sri Lanka, I held in Nagamani Theivendran versus the Attorney General that confessions under the Prevention of Terrorism Act, or PTA, in Sri Lanka required corroboration to establish the commission of the offense. The PTA, similar to the infamous Indian Terrorist and Disruptive Activities Prevention Act, or TADA, made admissible confessions made to police officers of a certain rank and imposed the burden of proving that any such statements were involuntary on the accused. Perhaps it was my years of experience as an original court judge, seeing the circumstances under which such confessions were coerced, that blunted my wisdom. For I was alone in my reasoning, though my brother judges agreed with me that the confession in that particular case lacked congruity and consistency, but they would not advocate corroboration. Let us at this stage look a little deeper at some of the cases highlighted by me a little while ago. For history is a patient teacher repeating herself often. 40 years after Hirabayashi and Korematsu, new information unearthed by Peter Irons, a political science professor, showed that the government knew that there was no military reason for the exclusion order but withheld information from the US Supreme Court. The US Congress gave compensation to the surviving internees. The convictions were overturned, though the Supreme Court decisions were not. US President Bill Clinton awarded the highest civilian honor, the Presidential Medal of Freedom, to Fred Korematsu in 1988. On the 24th of May 2011, the acting US Solicitor General confessed that the Office of the Solicitor General had erred in the Hirabayashi and Korematsu cases and considered them blots on its history. A year later, US President Barack Obama awarded Hirabayashi the Presidential Medal of Freedom. So the courts are misled to come to conclusions, and after years you come to know what the army, the military have been trying to do. In England, it is Lord Atkin's famous dissent in Liversidge versus Anderson that chastised judges for being more executive-minded than the executive. That is the proper law today in England. His words were powerful, and I quote, "In England, amidst the clash of arms, the laws are not silent. They may be changed, but they speak the same language in war as in peace. It has always been one of the pillars of freedom, one of the principles of liberty for which on recent authority we are now fighting, that the judges are no respecters of persons and stand between the subject and any attempted encroachment on his liberty by the executive, alert to see that any coercive action is justified in law." Unquote. Lord Diplock held in a later case that the time has come to acknowledge openly that the majority of this House in Liversidge versus Anderson were expediently and at that time perhaps excusably wrong, and the dissenting speech of Lord Atkin was right. Unquote. In Sri Lanka, when the presidential elections were announced in late 2009, shortly after the Attorney General's officers waxed eloquent on the perils of releasing the hundreds of thousands of hapless Tamils, nearly 250,000 were suddenly released. Those who were perilous to the entire nation as potential bloodthirsty terrorists were now safe voters. In one of its most cowardly acts, the Supreme Court of Sri Lanka is yet to make order on whether leave to proceed should be granted or not in this case, even though 5 years have passed, as I mentioned earlier. To give this dastardly act some context, leave to proceed is usually granted or refused by bench orders of single sentences. Be refused, that's all. Reasons are seldom given. To reserve order and not pronounce it for 5 years is an act of unforgivable cowardice on the part of Supreme Court. Let me hasten to add that the Supreme Court of Sri Lanka was not always lily-livered, cowardly. In 1937, in the celebrated case of In Re Brace Girdle, the court did not shy away from taking on the governor of Ceylon in a habeas corpus application, holding that the governor's powers were not untrammeled, and struck down the arrest and detention of Brace Girdle as illegal. Perhaps timorousness set in with the so-called autochthonous constitution of 1972, the first Republican Sri Lankan constitution, where judicial review was repealed and secularity snuffed out in contravention of the entrenched provisions of the previous constitution. It was a constitution that was passed by excluding the Tamils not only from its creation and promulgation, but from its application as well. One of the reasons for abolishing the appeal to the Privy Council in the 1972 Constitution was the same reason that was articulated by Baron Judge in England recently, that recourse to a supranational legal entity eroded sovereignty. The government of the time was clearly concerned about the possibility of a repeat of the Privy Council decision in Kodiswaran versus Attorney General 1969, which directed the Supreme Court to answer constitutional issues instead of hiding behind technicalities. In India, as Mr. Kannabiran pointed out, the intellectual rigor displayed by the Indian Supreme Court in dealing with property rights was missing when dealing with the right to liberty, such as the rights to free speech, association, and assembly. Some of its decisions were understandable. Justice A.N. Ray was pole vaulted over 3 senior judges and made Chief Justice clearly for his role in leading the dissent in the Kesavananda Bharati case, where the majority held that Parliament's amendment power could not be utilized to alter the basic structure of the Constitution. When faced with serious intimidation and interference, it stumbled, but then, once the danger had passed, the Indian Supreme Court took steps to safeguard itself from interference and took on a robust role. In Sri Lanka, we have taken things a step, or rather an entire flight of steps further, when we impeached our Chief Justice last year. The Court of Appeal, based on the Supreme Court's special interpretation on a reference made to it, struck down the impeachment without a judicial inquiry as unconstitutional. The Chief Justice was given around 1,000 pages of evidence at 4:30 p.m. and asked to present her defense by 1:30 p.m. the next day by the Parliamentary Select Committee that heard her matter. Eager witnesses were hurriedly summoned when the Chief Justice's legal team and the few honourable members of the Select Committee walked out of the shambolic proceedings. Parliament proceeded to impeach the de jure Chief Justice, and a de facto Chief Justice was put in her place. At the time of such appointment, the Court of Appeal order, supported by the Supreme Court's decision, was in full force and effect. Not a single judge of the Supreme Court had the courage to refuse to sit with the de facto Chief Justice, despite the judicial orders in existence that made the appointment a nullity. The Supreme Court itself thus disrespected its own judgment and, in my view, acted in contempt. To compound matters, the de facto Chief Justice himself nominated the Supreme Court bench to hear the appeal preferred by the Attorney General against the Court of Appeal order that struck down the impeachment. Such was the blatant disregard for the edict of justice being seen to be done. The Supreme Court did not think it improper that the de facto Chief Justice, the direct beneficiary of the impeachment, could hear and determine cases even though the appeal which would determine the validity of his appointment was pending. While the case was pending, whether he has a right to sit or not, he was carrying on. After several months, the Supreme Court reversed its decision and that of the Court of Appeal and held that the impeachment was now valid. Since then, a spate of political and highly irregular appointments have been made to the higher judiciary with scarcely a murmur from the bench. Getting back to the issue of national security, Professor Conor Gierty pointed out, and I quote, "The first concern is often now centered on security, with human rights fitting in the conversation only insofar as they can be seen not to detract from this prior focus," unquote. In an era of national security primacy, rulers of all kinds have found it to be a sanctuary for the prosecution of their own counter-terrorism or counter-insurgency efforts, suspending civil liberties and extending their authoritarian tendencies through the manipulation of the instruments of a democratic state. They make use of the democratic institutions for their own private agendas of their own. Let us focus on the question that is oft asked of human rights advocates. Is not national security more important than liberties and freedoms? In my view, the question is wrongly framed, for national security cannot be separated from liberties and freedoms. People could be kept safe in a maximum security prison. Does that justify imprisonment? The issue arises from our understanding of security and from the manner in which we believe security concerns should be addressed. As Robert McNamara, former US Secretary of Defense, once said, and I quote, "We have come to identify security with exclusively military phenomena and most particularly with military hardware. But it just isn't so." That's what he said. Looking at national security and how it is pursued in the contemporary sense, we could see that McNamara was not far off the mark. In an era of globalization and transnational threats ranging from terrorism to Ebola, threats of all manner have become an issue of national security. I would define it not as national security, which is really an euphemism for regime security, but human security, which is the type of security I cherish. தமிழிலே கூறுவதானால் ஆட்சியர் பாதுகாப்பு அல்ல, மனித பாதுகாப்பு தான் தேவை. ஆள்வோரின் இறைமை அல்லது அது எங்களுக்கு தேவையல்ல. ஆள்வோர் இறைமை, மக்கள் இறைமை எமக்கு தேவை. இதைத்தான் கூறி வருகின்றேன். Looking at national security and how it is pursued in the contemporary sense, we could see that McNamara was not far off the mark. In an era of globalization and transnational threats ranging from terrorism to Ebola, threats of all manner have become an issue of national security. I would define it not as national security, which is really an euphemism for regime security, ஆட்சியர் பாதுகாப்பு, but as human security, மனித பாதுகாப்பு, which is the type of security I cherish. As the UNDP's 1994 Human Development Report argued, ensuring freedom from fear and freedom from want from all persons is the best path to tackle the problem of global insecurity. The definition of human security was framed along 7 themes: economic security, food security, health security, environmental security, personal security, community security, and political security. According to a 2008 WHO study, World Health Organization study, 3.4 million people die each year from water, sanitation, and hygienic causes. Less than 18,000 people died around the world due to terrorism in 2013, and that year had a considerable spike because of an increase in violence in Iraq. Even snake bites kill more people than so-called terrorist activities every year, according to the WHO. Why is it that water security is not an issue? Why is hygiene not an issue? Why is so much of importance being given to terrorist activities and so on? I was very pleased to hear the recent emphasis placed by the Indian government on hygiene, going back to what Gandhiji did from his days in South Africa. In Sri Lanka, on the other hand, we have an epidemic of chronic kidney disease. Our health minister is here, you could ask him, which has reached this stage because for nearly 2 decades, nothing has been done about the problem, the root causes of which relate to water, nutrition, and health facilities. Despite years of warning on the instability of the land in areas where low-income groups have been provided line housing from during British times, no action was taken, resulting in the deaths of many unfortunate people 2 weeks ago in a landslide in Sri Lanka. I visited the affected area just a few days ago before coming here. We may ask the question, post-war, how many people have been killed due to private terrorist activities? What is the budget allocated to defense, and what is the amount allocated to ensuring safe accommodation? If security is viewed as human security instead of regime security, we would be able to resolve many of the so-called tensions between liberty and security. As I mentioned earlier, the release of 250,000 Tamils who were held in open prisons without any legal basis just before the presidential election in 2010 demonstrates a classic case of how regime security is given primacy. The people were incarcerated primarily to prevent the flow of information about the atrocities committed during the war and to ensure a change in the demography. Free flow of that information would have undermined the rhetoric of zero casualty and humanitarian mission and would have led to calls for prosecution for grave breaches of humanitarian law. The principle of command responsibility posed a serious risk to the regime. However, winning the election was a greater requirement for the regime, and the possibility of gaining a significant number of votes as gratitude for release was the thinking behind the sudden release. They were terrorists a few months earlier. Suddenly they are released because their votes were wanted. If human security was at the forefront, the release could have been expedited months earlier. If human security were foremost in their mind, the government of Sri Lanka would not have engaged in the bait-and-switch chickenery by announcing to the world that it has abolished the draconian emergency regulations in 2011, while persisting with the equally draconian Prevention of Terrorism Act. In fact, as Human Rights Watch reported, the then Attorney General had confirmed that the lapsing of the emergency regulations will not mean a change in detention practices, stating, no suspects will be released and there is no change even though the emergency has been allowed to lapse. That's what the Attorney General said. So what is this all talk about emergency being brought to an end? As I have repeated on numerous occasions, the militarization of the north of Sri Lanka, where I am the Chief Minister, takes place not due to any real security threat, but to maintain a stranglehold over the populace, over the Tamil people, Tamil-speaking people, to subjugate them and make them compliant, to stifle any form of democratic or political dissent. If human security were the guiding principle, the military would not be taking over people's lands, cultivating them with the owners having to buy the produce from their own land, and they are building hotels and golf courses when the dwelling homes of the people devastated by the war remain like pockmarks in the northern landscape. Today, cases involving more than 2,100 petitioners are pending before the Court of Appeal and the Supreme Court regarding the acquisition of 6,381 acres of land in Valihamam North, where an illegal high-security zone for the Sri Lankan armed forces has been set up. Despite such legal actions pending before the highest court in the country, the army continues to destroy whatever is left of the buildings, homes, holy places, or hallowed school premises inside the high-security zone. In fact, when I, as the Chief Minister, tried to visit such places of vandalism, I was politely told by the armed personnel manning those areas to obtain permission from the Secretary of Defense, who happens to be a brother of the President. I could not go within my area to see what has taken place. Such is the sorry state of our sovereign state's security concerns. If human security was at the forefront of the people would be allowed the freedom of association without needing to worry about the military. They need not grit their teeth and invite military officials even for school functions. You know, in the villages, even for school functions, the army insists that their people must be there. There would not be a need for foreign passport holders to obtain special permission to visit the north. This requirement was brought about barely a month ago, not because of any security threat, but because of the UN inquiry and the fear that more evidence would be collected. If human security was at the forefront, Sri Lanka would not have contributed to the lexicon with terms such as white van. I hope you know that. White van for government-sponsored or sanctioned abductions. When the government sanctions or sponsors abductions, they are taken in white vans. And grease devils for troublemakers who escape from the civil authorities for unleashing terror on the general populace and mysteriously seeking refuge in army camps. Surely it could be seen that these are counterproductive to security. We have long advocated a phased withdrawal of the military and the handing over of administrative matters to the civil forces according to a transparent timeline. How can human security exist when the people are under an occupying force? And indeed, the north and east of Sri Lanka are under an occupying force. If human security were at heart, there would be no systematic and continual rape and torture of Tamil men and women by the armed forces, as recent reports show. The BBC reported a man stating, "They would put my testicles in the drawer and slam the drawers shut. Sometimes I became unconscious. Then they would bring someone and force me to have oral sex with him. Sometimes, if we lost consciousness during the torture, they would urinate on us." Another woman describes being photographed and fingerprinted and then kicked, beaten with batons and pipes, burned with hot wires and cigarettes, submerged in a barrel of water until she thought she would drown, suffocated by having a petrol-soaked plastic bag put over her head, before being repeatedly raped by men in army uniform. Her relatives managed to bribe and secure her release after 20 days of this torture. Just a few days ago, a man was arrested for trying to gather evidence for the investigations being carried out by the Office of the High Commissioner for Human Rights. Is this evidence of regime security or human security? Or is this the new norm under which security imperatives rule the day? A norm under which embedding military in civilian life under the guise of civil-military programs, blurring the boundaries between civilian and military life along the lines of highly militarized states like Pakistan and other states elsewhere. This is what Mr. Kannabiran envisaged when he spoke of the state as a terrorist. I quote from him, "State violence under the cover of law and order and security of the state has been far more extensive in scale and destructiveness than private violence. State violence does not come to an end with the abatement of private violence. It continues its course to ensure that there is no protest because its purpose is political. The population must be reduced to apathy and conformism because participation in decision-making is viewed as a threat to democracy," unquote. State violence in Sri Lanka continues. The Tamils, though the worst affected by far, are not the only ones. When poor Sinhalese from the south dared to protest about the contamination of their water in Valliveriya, the military was unleashed on them with fatal results. Other minorities such as Muslims and Christians have been targeted with a view to project a government that is representative only of the Sinhala Buddhists and to portray new enemies and targets. As Plato observed in the Republic, and I quote, "When a tyrant has disposed of foreign enemies by conquest or treaty, and there is nothing to fear from them, then he is always stirring up some war or the other in order that people may require a leader," unquote. In Sri Lanka, as in Pakistan and other states, we are witnessing the growth of national security apparatus as a distinct power center within a democratic system where secrecy and industry interests dominate as the nexus between military, industry, and institutions of governance gain primacy. Lacking democratic oversight, the protection of democratic values and civil liberties has now become a process of bargaining with the dominant power center, the security apparatus. In the case of Sri Lanka, the fact that a single family controls the power centers, political and military, adds a new dimension to the state Mr. Kannabiran took on. I state these instances because they give a clear view of how regime security supplants human security as a governing principle. They are interested in their regime security. They are not interested in the people's security. The false dichotomy between security and freedoms can be avoided or minimized if human security becomes the guiding principle. And that is what I mean by safeguarding security and sovereignty. I therefore respectfully disagree with Lord Denning when he held in Hossenball case, and I quote, "There is a conflict here between the interests of national security on the one hand and freedom of the individual on the other hand. The balance between these two is not for a court of law. It is for the Home Secretary. He is the person entrusted by Parliament with the task. In some parts of the world, national security has on occasions been used as an excuse for all sorts of infringements of individual liberty, but not in England." That's what he said. Lord Denning's confidence in England is admirable but misplaced. Whether it be the trial of Sir Thomas More for treason in the 16th century or the war in Iraq in the 21st century, there have been numerous dubious instances where national security considerations have provided the cover for various activities. Lord Denning himself remarked in 1964, in resisting a claim that an official document should be privileged from disclosure. That's what he said in a different type of case. A practice seems to have grown up, he said, that all a Home Secretary has to do is to give a certificate and pronounce a spell to make it taboo, unquote. I see no reason why the Defense Secretary will behave any differently from the Home Secretary. I disagree with Lord Denning on his second assertion as well, that courts should defer to the judgment of the executive. As Oliver Wendell Holmes said, the life of law has not been logic, it has been experience. It is our different experiences that mold our opinions. Lord Denning seems to acknowledge this when he recognizes that national security is a convenient cover in many jurisdictions, and to that extent we are in agreement. He doesn't state what judges ought to do in those circumstances. Much of the UK case law tends to defer to the executive on questions of security, possibly as a result of their confidence that the executive would not misuse such power in England or in Britain. I wonder whether the level of confidence will remain after the Chilcot report on the inquiry into the war in Iraq is released very soon. The reason why I don't think courts should be differential to the opinions of the executive is mainly because of my experience with the executive using national security as a convenient cover and my understanding of how this has occurred throughout history, as I explained earlier. But equally important is the recognition that curbing individual freedoms and giving the government excessive power is setting the stage for a tyrant to abuse that power. Well-meaning people tend to argue that restrictions on fundamental freedoms will have to be made to ensure the protection of the people themselves. Thus, they will state that it is necessary at times to hold people without legal authority. What they fail to see is that every time such aberration takes place, the government sets a precedent to breach the law. This empowers unscrupulous elements to abuse that power. Could the presence of J. Edgar Hoover as the director of the FBI in the US at that time be the reason for the culture of misinformation and secrecy of Korematsu and Hirabayashi? Did that allow the hounding of communists, which they wanted done? Could the Watergate scandal have arisen 30 years later because of the gradual rise in impunity of the executive in the US during Nixon's time? These are difficult questions to answer. I would, however, wager that the executive in Sri Lanka was emboldened by the series of decisions made by the Sri Lanka Supreme Court in supporting bills and constitutional amendments and holding with the executive in fundamental rights cases, so much so that the leader of that very Supreme Court herself became a victim of the executive's wrath when she finally refused to toe the line. These are, in Mr. Kannabiran's words, the wages of impunity. Every time courts sanction illegal acts or fail to scrutinize the acts of the executive properly, they contribute to the culture of impunity. Every such step strengthens the executive and progressively weakens the judiciary and erodes democracy. The Sri Lankan judiciary has fostered a culture of impunity in many ways, sometimes very insidiously. One practice was how the Supreme Court dealt with fundamental rights cases dealing with illegal arrest and detention. The court makes much fanfare in asking the Attorney General to check with the defense authorities to see if the person could be indicted or released and to expedite that process. The argument was that this was an efficient way of ensuring that the defense establishment and the Attorney General would evaluate the matters expeditiously. What this did was to allow arbitrary arrests and detention to continue with no fear of consequences except in rare cases. It also ensured that there were no findings against the government which could be used in international fora to show the widespread human rights abuses that were going on. It gives me great pain to say that the judiciary in Sri Lanka, of which I was a part for a quarter of a century, has failed in preventing a culture of impunity and has contributed directly to the executive's authoritarian rise. The judiciary also played a major role in foisting second-class citizenship on the Tamil-speaking peoples. It has shown a systemic bias against minorities, as the recent research by 3 fearless lawyers show. Dr. D. Almeida Gunaratne, Kishali Pinto Jayawardene, and Gehan Gunathilaka, in their excellently researched book, The Judicial Mind in Sri Lanka Responding to the Protection of Minority Rights, describe how the judiciary as an institution failed the minorities in not only national security cases, but in relation to the language rights, land rights, and housing rights, and religious rights. The book authored by non-Tamils, mind you, book authored by non-Tamils, concludes that the rise of Tamil militancy in Sri Lanka cannot be divorced from institutional failure, including that of the judiciary to address genuine grievances, because, barring a few exceptions, the judiciary's treatment of minorities was fundamentally different to the general dispensation on the issue. Their findings with regard to the judiciary's role in public security-related cases is also revealing. From 1947 to 1979, the court did not appear to be racially biased, but was conservative. From 1979 to 2009, that is until the conclusion of the war, the court was inconsistent in its findings, but what is disturbing is that while the progressive cases were invariably those where majority community members were involved, the regressive and oppressive decisions tended to be where minority community members were involved. Post-war, the court transcended its anti-minority bias and instead became completely differential towards the executive. The regressive and oppressive measures against the Tamils did not just occur in the judicial arena. It also extended to the legislative sphere. As I alluded to earlier, the 1972 Constitution made the Tamil-speaking citizens of north and east of Sri Lanka second-class citizens overnight. B, unilaterally abrogated the post-independent pacts entered into by the elected Tamil leadership with the majority community prime ministers to resolve the ethnic conflict, such as Bandaranaike Chelvanayagam Pact of 1957 for regional councils in the north and east, and then Daddi Senanayake Chelvanayagam Pact of 1967 for devolution. C, it institutionalized structures of discrimination which resulted in the denial of right to land, right to education, and rights to development, and resulting disillusionment and disenchantment and frustration of the Tamil youth. And D, made the Tamil leadership, against the backdrop of singleization of the governance structures in Sri Lanka to the detriment of the Tamils, unable to secure an equitable and sustainable political settlement via democratic means. Such were the main causal factors for the genesis of the rise of Tamil militancy in Sri Lanka. This study on the failed judicial system and our experience with the constitutional process shows how over time impunity can grow and get out of control. The courts would not have realized, when they ignored the injustice heaped on minorities, that they were setting the stage for injustice to be heaped on all communities in the future. This is a function of untrammeled power, evidence of the propensity for impunity to grow exponentially, illustratively. It is precisely for this reason that I do not support deference to the executive. I remain suspicious of the concentration of power and believe that the judiciary must always have oversight over the functions of the executive. It has to be constantly vigilant and should ensure that the executive knows that it would have to justify its actions or be taken to task. The answer to our first question then is recognizing that the question is wrongly framed. we should take steps to address security concerns while ensuring liberties and freedoms. The first step is to inculcate the idea of human security into our thinking and ousting regime security from policy considerations. The second step is ensuring the rule of law and maintaining judicial oversight to ensure that no arm of the state is unaccountable or allowed to cloak itself in secrecy. This would ensure that there are no false dichotomies in practice. Judges Justice Zakaria Yaqub said, a little while ago, practicality is not accepting your lot. Under the guise of practical or practice or practical means, we accept everything as if that is the correct way to go through. And that is what he was referring to. This would ensure that there are no false dichotomies in practice. Judges and policymakers are not there to answer law school conundrums, but to address the issues before them. Let us postpone answering hypotheticals to the day we come across a case where liberties and freedoms cannot be adequately safeguarded whilst providing human security. Courts, as one of our more illustrious Chief Justices held, are not academies of law, but courts of justice. When one points out that injustices indulged in by the state, one is invariably termed, and I might be termed the same when I return to Sri Lanka, one is invariably termed as a terrorist, a Naxalite, communist, imperialist, separatist, or whatever term that is in vogue at the time to demonize and silence critics. Human rights organizations and civil society groups are oft termed Western lackeys and conspirators. Critics are viewed as fifth columnists seeking to undermine the sovereignty of state. This brings us to the question of sovereignty now. At the outset, I wish to point out that the labels and agendas of people who advocate human rights are largely irrelevant. In logic, arguments of this kind are termed ad hominem and are devoid of merit. Let us look at the substance of the argument instead. Let us look at the principle of sovereignty. Again, I cherish this principle, but the sovereignty I cherish is that of the people and the rule of law, and not that of the artificial construct of the state. இறைமை என்று நான் கூறும்போது ஆழ்வோரின் இறைமையை நான் குறிப்பிடவில்லை, மக்களின் இறைமையை குறிப்பிடுகின்றேன். Sovereignty of the state is the remnant of the divine right of kings from the days when sovereigns ruled. What we should focus on is ensuring that the people are sovereign and the rule of law is sovereign. The necessity for the rule of law and the consequence of the absence of it leading to a culture of impunity has already been discussed. How do we ensure that the people are sovereign? What happens if the majority wish to impose their will on a minority? This is where we have to go back to our concept of human security to ensure that no group is disadvantaged and that there is political security. It is easy to speak of sovereignty of the state in lofty terms, but that doesn't mean the world has to turn a blind eye, as it did in Rwanda, when nearly 800,000 Tutsis were massacred in just 100 days. President Clinton considered it one of his greatest foreign policy failures. In a damning internal report by Charles Petrie, the UN was criticized for failing in its mandate to protect civilians in Sri Lanka in the final months of the war, and the events were termed a grave failure for the UN. Contriteness is admirable, but is not prevention preferable? If India had not intervened in 1971, would not the genocide of Bangladeshis continued unabated? A state is morally entitled to claim sovereignty only when it is ensuring the sovereignty of its people and the rule of law by ensuring human security. In my view, sovereignty of the state is a representative sovereignty sustained by the sovereignty of the people in that state. This is not to say that countries should be entitled to use internal disturbances as a ruse to interfere, but that sovereignty should never be allowed to be a shield against violations of international law. In any event, it should be understood that in today's context, sovereignty of the state has become largely irrelevant. As Luis Moreno Ocampo, the former chief prosecutor of the ICC for nearly a decade, stated on BBC's Hard Talk around September 20th, 2014, the world order is changing where sovereignty of states is being eroded with greater power being given to supranational institutions. In an age of treaties and the recognition of greater jus cogens norms, is sovereignty still relevant? A jus cogens is a norm from which no derogation is permitted. The very existence of international law, in a sense, is a restriction on state sovereignty. For pacta sunt servanda to be obligatory as customary international law, pacta sunt servanda means agreements must be kept of pax. For pacta sunt servanda to be obligatory as customary international law, states are the subjects of international law and to that extent are not sovereign. Still further, in today's interconnected world, the problem in one country spreads to another very fast, as can be seen in the Middle East. The cultural, linguistic, and religious affinities across borders internationalize issues. The moment an issue is in one country has transboundary effects, the matter ceases to be a purely domestic issue, and all countries affected by it have a stake in the matter. Let us take the situation of the Tamil-speaking peoples of Sri Lanka. They were majorities in their areas of historical habitation from time immemorial, but they became minorities in the context of the whole of Sri Lanka. They have been discriminated against, politically marginalized, brutalized in war, and even the courts have a systemic bias against them and has consistently failed to protect them. Majoritarian policies have marginalized, disempowered, and alienated them. How is their security preserved? How is their sovereignty as human beings preserved, especially since the sovereignty of the rule of law has been eroded? As Avishai Margalit and Joseph Raz cogently argue, any idea of human well-being beyond the satisfaction of biological needs must give consideration to culture, which is created by collectives. If culture is recognized, then it follows that it should be protected politically. If it is entitled to protection, collective security is also an essential part of human security. If it is a part of human security, then it is but rational that culturally cohesive groups should have the right to govern themselves, for it is only they who can best protect their culture. It is this right that is self-determination.